Kathleen Folbigg will have her case referred to the Court of Criminal Appeal in a bid to have her 4 convictions quashed. Ms Folbigg was pardoned for the murder and manslaughter of her 4 children by the New South Wales Government in June this year. An inquiry conducted into her case found there was reasonable doubt in the evidence used by the prosecution, leading to her pardon. Ms Folbigg has maintained all 4 children died of natural causes related to rare genetic mutations. Her solicitor has released a statement saying the release of the final report of Mr Tom Bathurst KC is another significant positive milestone on Kathleen's 24-year journey to clear her name. Today and every day, Kathleen's thoughts are with her children. Mr Bathurst found in the report that Ms Folbigg was a loving and caring mother. This finding reinforces a personal truth that Kathleen has held in her heart for more than 2 decades. Now, the Australian Academy of Science is welcoming the report and the Commissioner's decision to refer the case now for appeal. Joining me is Chief Executive of the Academy of Science, Anna Maria Arabia. Anna, thanks for your time. I know that the Academy of Science was an independent scientific advisor to that inquiry. What does this case tell you about the need for reform in our legal system?
This second inquiry into the convictions of Kathleen Folbigg have demonstrated to me and to many loud and clear how important it is that we create a more science-sensitive legal system. The Kathleen Folbigg inquiry benefited from the Academy of Science acting as an independent advisor because we were able to suggest experts from the right fields of expertise to come forward and to be asked questions appropriate to their expertise. The justice system absolutely benefited from reliable and independent sources of evidence. But this was a once-off, and it ought not be a once-off that we support the justice system by ensuring that evidence is provided in a way that is well communicated and that is engaging and able to inform the decisions of the justice system. So for me, it is a remarkable demonstration of the sort of law reform we need to ensure that this is not a once-off case.
You want to make the judicial system, as you put it, science sensitive. What's the standard across our jurisdictions now when measured on that capacity to take in scientific evidence?
Well, at the moment, experts are called to give evidence to court cases, hearings and other proceedings by the prosecution and defence. They are not always the most expert in their field. They may be the person who is available or the person who a legal firm or others might rely on to give evidence. And it is a very adversarial engagement. So often scientists who do appear as expert witnesses report to us about feeling quite cornered and not being able to communicate the whole evidence base that they are able to contribute to decision making in the justice system. There's also an absence of a reliability standard in our justice system, and that would a reliability standard would enable the justice system to know that evidence that is brought forward is reliable and can be admitted to court for consideration. In the absence of that standard, we don't know how reliable evidence is. So introducing law reform that would see the introduction of a reliability standard and the independent selection of experts would enable our justice system to be better informed and more reliably informed with evidence to enable the justice system to make the most informed decisions. And I think that's what we all want. We want a justice system best enabled to be able to deliver justice to the people of Australia.
And one of the things you're also arguing for is the Criminal Case Review Commission. I understand it does work in a number of comparable nations, democracies around the world. And I've seen one number that law experts are estimating if we were to have such a commission, we would see 15 cases per year referred to it and potentially 11 of the 15 convictions overturned. That's extraordinary.
It is, but let's contextualise that. So I think comparisons are made on a population comparison with the UK that does have a Criminal Case Review Commission. And for your viewers, this is a mechanism that once all of the appeals mechanisms have been exhausted, enables new or complex and emerging science and evidence to come forward. So it creates a legal mechanism for the consideration of that new evidence. So if you did do that population comparison based on the UK and Australia, at least at the beginning of the introduction of a Criminal Case Review Commission, you would expect a bit of an uptick in the number of cases referred to it. But what would happen as the system is made more science sensitive and strengthened is that you would expect a decrease in the number of miscarriages of justice. So you could have a large number at the beginning referred to a Criminal Case Review Commission. That does not mean all of those would be overturned, but it is a mechanism to enable consideration of those cases where there is new evidence. And you would expect an equilibrium to be established and things would balance out over time.
Anna Maria Arabia, Chief Executive of the Academy of Science. Thanks for your time and your insights. Appreciate it.
Thanks for having me.